Good evening and welcome to this forum on warrant articles for the upcoming town meeting. It's sponsored by the Brookline Neighborhood Alliance, the Town Meeting Members Association, and the League of Women Voters of Brookline. And we all appreciate Brookline Interactive Group, BIG, for recording and televising this event. We're going to be talking about 4 articles that are on the warrant for town meeting. Article 13, Article 8, Article 12, and Article 15. For Article 13, we'll just have a brief update from the petitioners of that article, Bobby Nabel and Ruth Ann Snyder. But we'll have a debate format for the other 3 articles. And this is similar to the format that we've used in previous events. The opening statements will be 5 minutes per side, not per speaker, but per side. Then there'll be an opening statement from the proponent and the opposing side, and then we'll open it up to questions from the audience. Questions shouldn't take more than 1 minute, and they should be directed to both the opponents and the proponents neutrally, because they'll both have a chance to answer with a maximum of 2 minutes per answer. Closing statements will be limited to 3 minutes per side, and by a random coin flip process, it turned out that the proponents will speak first on each article, and also they'll have the opportunity to make the final closing statement. That was random, and it just turned out that way for each of them. We will have a timekeeper, so if you are speaking on these articles, please adhere to the time limits. We'd like to finish by 9:30, so we would appreciate your cooperation on that, and you will be warned when your time is running out. I also would like to mention at this time that these articles obviously aren't the only ones on the agenda for the upcoming town meeting, but they are the ones that seem to inspire some of the most debate in the various sessions of the advisory committee and other committees, Board of Selectmen, leading up to town meeting. We obviously could have considered more, but these seem to be 3 interesting and important articles that a lot of people have had a lot to say about. Article 13, the first one to be considered, is a little bit different because of the issues have been resolved, but it's an issue giving notice of Board of Appeals meetings and having access to the minutes of those meetings that's very important to the Brookline Neighborhood Alliance's members. And since the BNA is one of the co-sponsors of this event, BNA had a particular interest in having a brief conversation about that article. Without further ado, I'd like to turn this session over to our moderator, Amelia Koch of the League of Women Voters, who will provide the expert and impartial moderation that she has provided at so many of the previous sessions. We appreciate her doing this. Amelia?
Thank you very much, Sean. And which one of you would like to begin tonight? Very good. Bobby?
It may be helpful for you to know something about the particular case that led to the drafting of this warrant article. Ruth Ann Snyder and I became involved in this issue in 2011 when we both attended a ZBA hearing. I, having chosen at random a hearing to learn more about ZBA issues and proceedings, and she, because she had been asked for advice by an abutter in the appeal who was a constituent in her precinct. A fire had damaged the 3rd floor and attic, a single unit of a 3-unit condo. The building department denied the owner's application to establish 2 separate units each with its own entrance, based on the fact that separating the units had been ruled illegal a number of years before. The owner appealed to the ZBA. 2 hearings were scheduled and continued, the last in July 1911, with no date certain set for resuming the hearing. When we checked the ZBA site online this summer before drafting our warrant article, there were no references to that appeal, no description of the hearing, of continuances granted, or of a final decision on the appeal. To our knowledge, no decision has yet been rendered by the ZBA, and there is no agreement about whether the appeal has been withdrawn or whether the continuance is still in effect. As far as the public record is concerned, it is as if the appeal hadn't occurred. Our warrant article is intended to correct what we experienced as hindrances to the public's efforts to be informed about and to participate in the public process regarding ZBA proceedings. Information about appeals brought before the Board of Appeals is of importance not only to the petitioner who seeks to carry out a project, but also to abutters and other neighborhood residents whose enjoyment of their property, and sometimes the monetary value of that property, may be affected by the outcome. Failure to make such information available in a timely manner limits the ability of the public, including town meeting members from the affected precinct who want to be informed about issues that affect their constituents, to participate in the hearing process. The intention of this bylaw amendment was to ensure that interested parties in cases brought before the Board of Appeals are provided information at crucial times during the consideration of the appeal, and when a decision has been reached, and to ensure that members of the public have access to the public records regarding those appeals within a reasonable time. Improved access by town meeting members and town residents to information about appeals would increase opportunities for them to participate in the appeals process. The Planning Department was recently assigned responsibility for, among other things, issues related to communication between the ZBA and various constituencies. It has been very sympathetic to the concerns that led to the drafting of Warrant Article 13, has met with us a number of times to discuss implementation of improved procedures. As a result of those conversations, the Planning Department has indicated that it will institute the following procedures intended to meet the needs of residents and town meeting members for timely information about hearing outcomes. Posting online a summary of ZBA hearing outcomes within 5 business days of the hearing, and approved minutes, usually within 21 days of the hearing, with minutes in draft form available in the interim on request from the Planning and Community Development Department. The combined reports contains a more detailed list of changes in procedures. We very much appreciate the willingness of the Planning Department to address our concerns, their consideration of suggestions we made, and their prompt implementation of measures to deal with issues raised in the warrant article. These changes address the elements in our warrant article, and for that reason, we move no action on the article. One last comment. As we discussed our warrant article with various town groups, people mentioned a need for improved communication and procedures related to planning and ZBA outside the areas addressed in our warrant article. And based on the principle that no good deed goes unpunished, we look forward to conveying these concerns in future discussions with the Planning Department staff.
Thank you very much. Are there any inquiries from the audience? All right. Ruth Ann, would you like to make any quick statement before?
No, we've written
All
the
right.
speech together. Thank you.
Very good. Thank you both very much. And would those involved with Article 8 come forward?
Choice is yours.
Just as a reminder, we've got 5 minutes opening remarks from both sides, and the proponents go first. So, Chief O'Leary, do you wish to split your time with Are you there, Ruth?
Yes, Patty Career and I will split our time.
Terrific, wonderful. Just keep an eye on the timekeeper.
Good evening, I'm Dan O'Leary, the Chief of Police, and I'm here for warrant Article 8. Warrant Article 8 is an article that we suggested changes to the current bylaw that deals with disorderly conduct and disturbing the peace. These changes are the result of a request made by town meeting a year ago when an update was made to the bylaw that people wanted to increase some of the fines that could be assessed for violating the bylaw. When that was first looked at, some of the wording that was in the bylaw at the time was no longer constitutional under our laws. Suggestions were made to make those changes in 2013 when it was up in front of town meeting. It was not allowed because it was beyond the scope of the warrant article. And then we were asked to take a look at it and come back with the proposed changes. So the changes that we're proposing as part of this warrant article, they're really to bring this entire bylaw into compliance and to make it legal and lawful for our officers to enforce it. Just to go over some of the changes, first of all, we renamed it. We named it not only disorderly conduct, but also we included language of the disturbing the peace statute and the disturbing the peace case law. And that's because they flow together pretty good. We did suggest that we were going to delete some of the sections in there, and I'll go over them quickly. One of them was the phrase quiet enjoyment, and that was added in 2013. However, when it was looked at more closely by Patty, it really pertains a lot to the landlord-tenant relationship. And it's also, when we made the entire change, we added the definition of disturbing the peace, and it's covered under that definition. So it's already addressed in the change that we proposed. Another thing that we recommended to delete was the wording who makes an offense or coarse utterance, gesture, or display, or addresses abusive language to any person present. According to the Mass Supreme Judicial Court recent decisions, that's an unconstitutionally overbroad and invalid phrase to use, so we deleted it to stay in compliance with the recent cases. What we also did was we took out a definition of one entire section here, and the entire section here is section 8.5.3, and in it talked about limiting, about making offensive or disorderly language to persons of the opposite sex, and that was ruled or is suggested in some of the cases that have been ruled on by the SJC that that clause in and of itself would violate the Mass Civil Rights Act. And because of that, we deleted it in its entirety. And if you take a look at the changes that we proposed in section 8.5.1, that is all covered under that. We just don't use that phrase. And I'll turn it over to Patty.
Yeah, just to briefly add just a few additional points. What Chief was talking about in terms of deletion of 8.5.3, which prohibits abusive language against people of the opposite sex. So that was deleted, as the Chief explained, because the Massachusetts Equal Rights Act requires equality of treatment between the sexes, and there was a Supreme Judicial Court decision saying that that language seems to raise a constitutional issue under the ERA by singling out abusive language against a person of the opposite sex. Why wouldn't it be people of both sexes? And then it would have to rise to the level of fighting words. It couldn't just be offensive conduct. So as the Chief was explaining, there have been changes suggested to 8.5.1, which encompasses fighting words against all people, not just people of the opposite sex. It prohibits that. It prohibits fighting words, and it prohibits now the addition of disturbing the peace. So those are fundamentally the changes.
Very good, thank you very much. And now, speaking against, we have Regina Frawley and Rita McNally, both town meeting members. And please, you have 5 minutes to speak.
Good evening. I'm glad to see a packed house. Thank you all for coming. And I'm Rita McNally, from town meeting member from Precinct 2. And my objections to Article 8 was that I was surprised that it was presented to the selectmen, and I wanted to know why, because I was under the impression at last year's town meeting that we were going to have a committee that got together and we were going to try and straighten out Article 8 so that we all were clear on what it was actually stating, what it was about. And I think Patty has done a tremendous amount of work on it, but I think there are still other parts of Article 8 that have to be made clearer to people so that they know what the law says. And I think it's a piecemeal approach. The changes that come on, we changed it in 2013, we changed it in 2010. We were going to change some of it in 2012, but we couldn't get it together fast enough. Now we're offering changes in 2014, and there's still going to be holes in it. First of all, I'll mention something before I forget it. There was a change to the fees, to the penalties, from $50 to $100. I'd like to add a 0 to that and make it $1,000. I think that you have to have a real penalty on this if it's part of our bylaws, and that it's really disturbing people, and it's at a level that in order to reach it, it has to be egregious, it has to be intentional. So I think that making it from $50 to $100, you can pay more than that in a week of fines, you know? So I thought that that really needed to be looked at and to be talked about. And Article 8, in my reading of it, seems to be implying neighborhoods. It's about residences. It's like the noise outside of residence or the party streets. Does that mean I'm over 3 or?
No, we've got 3 minutes to go.
Oh, okay, well, I'm just going to take another minute. So I had also wanted some reference, some guidance about the kind of behavior that operates in some of our meeting rooms at Town Hall or at the Health Department or other places where we're having a meeting, say someone shouting out or speaking over someone that would be speaking here. I'd like to see that, and I'm always told, and I mean always, oh, it's covered in the noise bylaw. No, it's not covered in the noise bylaw, and I think it should. We should have some statement that disturbances at public meetings, when discussions are taking place, that kind of disrespectful behavior has to be stopped. We have to have what the rules are so that we all know that there's certain behavior, and believe it or not, there are some people in this town that don't know that their behavior is not acceptable at meetings. And I also want something other than the residences to be referred to. There was a reference at our memorandum that Patty wrote to give more of an explanation to those that were interested in this issue, that the open meeting law would cover this kind of behavior at different meetings, and you know, and how the chair would be in charge and would set out the agenda, et cetera, and that would take care of everything. I've been to 4 open meeting law discussions, and I've never heard that at any of them. So I really think it has to be discussed. It's part of how we operate in this town, and everybody needs to know. The case law often that was used and referred to as being behind some of the changes often spoke of may or alludes to. It was legal language that wasn't saying shall, must, is. And I think that that's why I wanted a committee to study it. And then I think the coverage is not adequate, and Regina can take the minute and a half.
I'll try.
Sorry.
Hi, Regina Frawley, town meeting member from Precinct 16. And in international law, if you have a definition of anything, even a purpose of anything, it has no legal weight. It's just a guidance. And so what remains involving any kind of public fuss, ruckus, whatever, it's just the definition. It's not adequate. We need to study this. We have these fines, and they've never been enforced. We have the previous law, and it's never been enforced. We have years of study, as Rita said, and we keep piecemeal dealing with it. There is a new culture that has been evident at Town Hall, and what we need is to take this now as a comprehensive study, preferably a moderated study committee. And we need to look at some of the laws that were cited here, which I have a different read on, because, for example, the disorderly conduct, if somebody is vulgar in speech, if there's evidence, including witnesses, and it appears to be a threat, which Patty acknowledges in her discussion here, it can be enforced, but if you remove it altogether, it's less enforceable. Thank you.
Very good. Questions from the floor? And please, if you would, if you have questions, step to the mic.
They're not shutting it out.
They're not. There being none, we could move to closing arguments, and I'm going to hold, do. Very good.
I'm just wondering, Ms. Frawley stated that the law's never been enforced. Is that true, Chief O'Leary? Has no one ever been fined for misconduct?
I don't know of when this law was applied under town bylaw. I do know that we use a very similar law, which is the state law on disorderly conduct and disturbing the peace. That's been enforced on numerous occasions.
But not concerning Town Hall issues.
Well, let me respond to that. So, as Chief O'Leary said, this is really just a fix. This is looking at Supreme Judicial Court case law that in turn looks at Supreme Court case law under the First Amendment and just adopts language, the very language that those courts have said is constitutional. If we don't do that, the policy of the town, this bylaw, that is town policy, will be unconstitutional, which could subject us to infringements on rights and potential liability. So it is important to fix this and do it in a way that's been prescribed by the SJC. So it's a criminal law. It has to reflect constitutional parameters, and it could apply still to public meetings. However, there are other, perhaps more nuanced tools for people running public meetings to address disturbances rather than a criminal statute. But if we do have a criminal statute at our disposal, it should be constitutional, and it should not expose people to criminal enforcement by police officers based on language that is incorrect language. Thank you.
Could I respond as well?
Yes, you may.
The other issue is there's no means of communication with the police, who are the enforcers, and the investigators. There should be a process, and there is none in place. So if, for example, I were to complain to the Board of Selectmen or to Town Council, there's no mandation that they have to contact the Chief of Police. And when this was brought during the study period of this article a couple of weeks ago, the chief said, well, I didn't know about it. We think that needs to be remedied. We need to have an automaticity to the process so that there is a form, just as there is for the citizen complaints against the police. There should also be a form at Town Hall and a guidance, instructions for every citizen what their rights are. Most of us, as involved as we are into the town, had no idea about Article 8.5. Another reason why it needs to be studied.
Any more questions? There being none. Closing arguments, and they begin with the opponents. Please. Yes.
I'm sorry, I didn't hear you.
Closing arguments begin with the opponents.
The opponents.
Oh,
Go
you want me to
Rita.
go ahead? Oh, sure. I was curious as, and this is addressed to Patty. Patty, the spelling of the word chorus, I know that in some places it's C-O-U-R-S-E, and it means C-O-A-R-S-E, and it doesn't always have the parentheses with the S-I-C in it, even though in the case law that you've given us to read, it is listed as sick, so that people know that it's misspelled. Is there a problem with making it spelled correctly? I think in the past there was.
Well, this proposes to delete that altogether because it's unconstitutional.
Okay.
There should not be language in this bylaw that prohibits and subjects people to arrest for coarse language. That's Supreme Court case law, and that's also SJC case
So
law.
that when it's in our law, that it'll be taken out?
Yes, this
That-
proposes to delete the
Okay.
unconstitutional language.
All right. I would just like to repeat that I think that we need a broader committee to also come together. Patty's done some terrific work bringing together the legal cases, but there may be more, and there are ways that we can think through, I think, so that we don't have to each year keep chopping at these, that we can do it in a whole sense of this, and then make a way that we can communicate with the police on this and find ways so that they're always within the mix, so we have their counsel as well, and find some ways of dealing with this, because it's happening, and not just in neighborhoods, but at the town hall and the health department as well.
I was wondering why you didn't just remove of the opposite sex, which would have also removed any gender identification. That's one question I have.
As we've said, it's because when you delete that, you can add of the opposite sex of the same sex, it's wordier, or you could just say person. And 8.5.1, as rewritten, addresses conduct against persons.
But it's only the definition, and that's what I'm concerned about. There's no motion that specifically addresses a violation of a bylaw. It's just contained in the definition.
Well, the definition, if you read it, has the actual content of what's prohibited. So the definition prohibits fighting words, disturbing the peace, tumultuous behavior. That is what the SJC has said is prohibited, and there is mandatory language in the definition prohibiting that.
Is that the juvenile case that you're referring to?
I did a memo of October 8th that has a list of cases detailed.
Right.
One of them was a juvenile case. There are other cases that were cited.
But if it does constitute a threat, and I believe your explanation says that, and that's a perceptual thing, but there can be evidence that indicates others perceive it as well as the victim, it can be, coarse language can be. It didn't just ban all coarse language, it said if there's a constitution of a threat.
It cited to the SJC in the cases I discussed in the memo, cited to a long litany of Supreme Court cases that have said you cannot arrest someone for coarse language.
So is that complete now? All right, no, excuse me, Regina and Rita, are you complete?
Oh, we're finished. I'm finished.
Yes, great, very good. Okay, so Chief O'Leary and Patty Correa, you are welcome to 3 minutes of closing arguments.
I just have a just two quick points. And one is, as far as the accessibility of the police department to file a complaint. Normally, when something is called to our attention, it's called directly to the police department by somebody, and we'll assign an officer to it, and it'll get investigated, and we'll decide whether there's enough evidence to go into court. That doesn't, anybody can do that. It doesn't need to be anything out of the ordinary. Phone call, letter, or a visit to the police station. Furthermore, complaints can be taken out next door in the courthouse at 360 Washington Street. They can go in and see a clerk of court and take out their own complaints if they think they've been wronged. And another thing, this bylaw, as is currently written, does not meet the standards of the law. And we can't leave this on our books and have it there in the possibility that it's going to get enforced by one of our officers, or they're going to charge somebody, and that's not fair to anybody, and it's going to leave us in a very precarious liability situation. And I think that's our big point here, is that we're trying to put a law in the book that is actually up to standards of today's court decisions, and that's simply what that is.
I'll just add that in the process of drafting this, I did consult Sarah Wunsch from the ACLU and Marty Rosenthal, who took one of the cases cited in my memo up to the SJC. It's his case, and he's also an expert in this area, and he, with PACS, I believe, feels that these are proper changes to make to the bylaw.
Very good, thank you all very much.
Thank you.
And now, if I could call those representing Article 12, zoning for registered marijuana dispensaries, to the table. Thank you very much. And For, we have Gordon Bennett and Daniel Saltzman, who are the petitioners. Against, we have John Doggett and Norton Arbelas from the New England Treatment Access Incorporated. So we'll begin with open arguments, and those will be 5 minutes for each pair of you. And we begin again with the proponents. Please watch the timekeeper.
Just need to hook up my computer. While I'm doing this, I'd like to just say good evening and thank you for allowing us the opportunity to speak. Having a little problem here. I don't know if anybody from Brookline Interactive could come out. Might have to sit there and use that computer. There we go. It should just come on. Just not seeing it.
It's just not seeing it. Let me check the control. It's good down there.
Working on that computer? Should I use that one?
Yeah, that one was fine.
Okay. Apologies, everybody. Let's see if we can drag it in. Okay, another phone.
Here it goes.
That's
Can you just do your thing?
we can just drag it. Excuse me, gentlemen. Here we go.
Fortunately, we were running ahead.
Yeah. Can I just go through it?
Okay, this is unfortunate. Yeah. Give it one last try here. It's not gonna
Pull it
work.
out of full screen. And then do the desktop show back up. Yeah. It disappears. I've never seen that before.
It's your computer.
Just go through it.
All right, I'll pull it out of full screen. All right, we're unable to get it to show up the way it's supposed to, but this will do. That's for sure. Sorry about that, everybody. I'm going to launch right into it because I've wasted enough of your time. I want to explain sort of the backdrop of Warrant Article 12. And again, thank you for having us here tonight. It's important to understand the regional scale of the operation that is going on here. We have 2% of the population securing a prescription. We have a Brookline RMD drawing from a pool of hundreds of thousands of people. Average customer making 2.5 purchases a month, 7 days a week, 9 hours a day, 17,500 customer visits a month, 65 visits an hour. Average monthly purchase quantity, 1.6 ounces. These are all numbers that come right from NETA. The projected selling price is $300 an ounce, and that's $100 less per ounce than the street value. The projected monthly sales is somewhere around $3.3 million, predominantly will be in cash, and that's nearly a ton of marijuana. It's a lot. So it's the scale that is important here. If this were just a small operation that was going to be going in every neighborhood in Brookline, it would be a very different story. We have a regional distribution center that is being proposed. There's going to be 8 to 11 sales counters. They have a building that's almost 10,000 square feet, the Brookline Bank building. So what's the impact on the neighborhood? Well, there wouldn't be, I think, an impact if this were not a regional dispensary. I wouldn't be here tonight if medical marijuana was distributed at CVS or something like that. It's the size and the scope of this operation that make the impact significant. There's traffic issues, parking issues, but importantly, there's a secondary market, there's diversion. Both state and federal government recognize proximity of vulnerable population to drug-related activity as high risk. Now, let's be clear. I'm not suggesting that everybody going into a dispensary is related to drug-related activity. It's a small percent, there's no question about it. By the former CEO of NETA, the estimate is 18% of the medical marijuana from the dispensary will be diverted. How many people will be involved in that, what percentage? I'm not sure. It will happen, though. We know that there will be a secondary market. We know that proximity matters. So, the Brookline bylaw compared to the state standards and the federal law. I think what's important here is not so much the current Brookline law, but what Warrant Article 12 proposes. As you can see, very similar to the state standard. It simply drills down a little bit on facilities in which children commonly congregate, and instead adds playgrounds and parks with play structures. Now, the federal law is something that we didn't know about when we started, when we wrote Warrant Article 12. We just found out about this a couple of weeks ago. The federal law is really what you need to reach, because the federal law is what's actually being enforced. And that's the important thing, is they are enforcing the federal schoolyard statute that you see up there. It says that a dispensary has to be located, it doesn't reference a dispensary, but in effect, what it does is it requires a dispensary to be 1,000 feet from a school, a park, or public housing. Warrant Article 12 produces nearly identical results when compared to the federal enforcement zones. That's what's important. Why is the federal law important? Hundreds of dispensaries have been closed in 6 different states over the past few years because of citing something that violates the schoolyard statute, the federal law. So what have other communities done? Most of the communities, almost all of them, at least in the area around Brookline, all of them have done something either more stringent than the state standards. We are the only town that has done anything less stringent, the only area. There's, we know that, I think it's Northampton has done something less stringent, but if we're going to compare things, we want to compare the towns in our area. You can see up there, everybody has gone more stringent than Brookline. So why Warrant Article 12? Complies with federal enforcement, it aligns us with the state guidelines, it allows for an appropriate citing of a needed and necessary RMD in Brookline, It meets the needs of the critically ill while safeguarding our children, families, and vulnerable citizens. So where can it go if warrant Article 12 is passed? There's one location in Coolidge Corner that we will right up front say we don't think is a great location, but that is one area that it could go. A very good location is in Chestnut Hill, out at the end on Route 9. There's plenty of parking, there's plenty of availability, and it is an appropriate place. It sites it somewhere that people can get to it, there's parking, and it's not in a place that is frequented by children and families all the time. So we have, can't see any of the information here, but basically there is plenty of space available if warrant Article 12 is passed. This is not a ban on dispensaries in Brookline, quite the opposite. There is plenty of location under warrant Article 12. So it achieves the federal enforcement standards, it aligns us with the state default standards, it enables dispensaries in Brookline, assures access to medical marijuana for the critically ill, reduces the risk of diversion, and it mitigates secondary effects. And we ask you to consider, when you're looking at these facts, I'm going to ask you to consider one thing. You know, what am I doing up here tonight? Gordon and I, we first heard about this a few months ago. We both supported medical marijuana. We both still support medical marijuana. So why are we here? We're here because what we supported when we voted for the state referendum, and I'm not a town meeting member, but I would have supported it a year ago, as most of you did. What we discovered is that this is a regional dispensary. It's going to serve hundreds of thousands of people. It's not just for Brookline. There's only going to be one here. And the impact is very, very different when you have that type of operation. People have said that we're being disingenuous. You know, I'm here tonight because I care about Brookline. I've lived here for 10 years. I'm going to be living here for the foreseeable future. You know, I care about this town. People have said we're being disingenuous. I can't tell you how much that pains us, because disingenuous, I mean, that's just a euphemism for lying. We're not up here lying. We're here because we support Brookline. Been doing that since I moved in here, and we'll continue to do that. And I just ask that when you listen to these facts, that you understand that. I'm here because I care. I'm not here because I'm being paid. And we support medical marijuana. We support the needs of the critically ill. Thank you.
Very good. So you're complete now?
Yes.
Very good. Okay.
Good evening, Madam Moderator. First, I'd like to take a moment to thank the Brookline Neighborhood Association, the Town Meeting Members Association, and of course, the Brookline League of Women Voters. This is an issue of national concern. We now have 23 medical marijuana states in the country and the District of Columbia. The ballot question passed in the Commonwealth in 2012, and the state has authorized up to 35 registered marijuana dispensaries. Currently, 15 are set to open in the next 12 months. This has been a long, arduous, and thorough process, and one that I think is important, because as a community that is proud to have options for its residents, that is proud to be compassionate, certainly we can all understand that safe, legal access to regulated cannabis is very important. Brookline overwhelmingly supports medical marijuana. Question 2 passed with 75% approval in the town, and we see that approval follow through to this very day. The merits of warrant Article 12 have been discussed thoroughly by many committees in town. If we look, for example, at the Zoning Bylaw Committee, which met on October 27th, their conclusions are as follows. Warrant Article 12 would in effect be a ban, a moratorium on safe legal access in the town of Brookline. The committee discussed the danger of diversion of medical marijuana to others, and they saw no evidence that the area in close proximity to an R&D was more likely to be a place where diversion took place. After thorough discussion of the issues, the Zoning Bylaw Committee unanimously supported the current zoning bylaw, which makes for a 500-foot buffer from schools, which disallows RMDs to share a building with daycares, and which sets forward a process of licensing, of annual renewals, and of possible restrictions on the license through the Board of Selectmen and the Zoning Bylaw Committee. We also had the Planning Board on October 2nd that came to the following conclusion. Brookline citizenry voted overwhelmingly in favor of allowing medical marijuana, and Brookline's town meeting also strongly supported the RMD zoning established in fall of last year, 2013, to revise that zoning, which was adopted after considerable thought and debate, with a regulation that would effectively prohibit RMDs in Brookline, runs counter to all previous public efforts, and therefore the planning board voted unanimously no action on warrant Article 12. The Advisory Council on Public Health on October 16th met and discussed this issue, and this is an important group of individuals. They are public health professionals. They are medical doctors who studied whether there was a connection between warrant Article 12 and public health. The Advisory Council on Public Health unanimously recommended no action on Article 12 by a 6-0 vote. On October the 28th, the Board of Selectmen met to discuss this issue, and their conclusion? A larger potential buffer zone, such as those including parks with playgrounds, daycare centers, and places where children congregate, in essence, warrant Article 12, would effectively create a de facto ban on these facilities in Brookline. After consideration of public comments at its hearing, the Board of Selectmen felt that the best way to regulate RMDs is not through further restrictions on the allowed locations, but rather through the conditions that can be attached to any zoning board of appeals, special permit, or Board of Selectmen licensing. The Economic Development Advisory Committee also voted unanimously, if not overwhelmingly, no action on warrant Article 12. What's important to note is that warrant Article 12, in any of its iterations, 100 feet or 500 feet or 300 feet, is essentially, there's only one constant, and that is the former Brookline Bank location, and really knocking that location out. This is an exercise in spot zoning, which is bad public policy and certainly anathema to good land use principles. Are we to deduce then that the process is broken in Brookline, that every committee that has looked at this issue has come to the same conclusion, no action on warrant Article 12? Or are we to deduce from this long and thorough process that, though well-intentioned, and that's important to note, though well-intentioned, warrant Article 12
Thank you,
is
Mr.
without
Arbelis.
merit
Opening
and
remarks are
deserves a no
now
action.
concluded.
Thank you. Appreciate
Thank you
that.
very much. And now I'd welcome questions from the floor. If you would please come to the mic. After the gentleman, yeah, please.
Thank you. Good evening. The proponents of warrant Article 12 showed a few maps, one of which was Coolidge Corner. Is there any evidence to show that there are more children present in the Coolidge Corner area compared to the Brookline Bank area? Seeing as the devotion school is there, the proximity to it, I just find it highly improbable. Thank you.
So now each of you has 2 minutes. Each side has 2 minutes to respond to this question.
Yeah, my name is Gordon Bennett. I live at 55 Davis Avenue in Brookline. I'm one of the petitioners. I would say that it's not our preferred location. I think there are children there. There's no doubt about it. Are there as many children there that are in Brookline Village? It's debatable. I know that there's Old Lincoln School is within 1,000 feet of that location. There's the New England Institute of Art across the street. There's 3 playgrounds there. And by definition, those places have more children than that location in Coolidge Corner. Again, it's not my preferred location. There are children there. The location out at Chestnut Hill is preferable. There certainly will be children there. But the idea is to try to move it away from where there are lots of children. And granted, there are no ideal locations, but I think there are better locations and worse locations. Thank you.
There are no perfect locations, but certainly we submit that our chosen location, the former Brookline Bank building, is about as good as we're going to get in town. There is access to the T to the Green Line. It is off of Route 9. inherently, by its former use as a bank, is one of the most secure buildings in town. Let's remember that there will be no signage, there will be nothing that indicates cannabis leaves or anything like this. Really, the core of the regulations is to keep it away from unauthorized end users. So as to your question, you know, I haven't been in the Commonwealth long, but certainly it strikes me that Coolidge Corner is not a preferable location to our chosen site.
Very good, thank you. Next question.
Yes, hi. I've been attending these meetings, but I myself didn't know about the federal law, even though I voted for this article last year. I didn't know that it was technically a violation of the federal law. And with due respect, even when the petitioners brought that to a meeting where I learned about it, I went and got my own maps, and I wanted to verify it. And I was quite surprised to see that in July of 2013, before we ever voted that fall for the article for RMDs, in fact, it was known at Town Hall that 1,000-foot setback was required by federal law. And to his credit, Mr. Vera, the acting CEO of NETA, submitted a letter saying that it could be closed because it's in violation of federal law. So my question basically is for the one town official here, or anybody who can answer it. Why was that ignored a whole year and a half ago? And as a town meeting member, why was I not informed that that was a violation of the federal law and what the consequences might have been?
And the questions are to be directed to both parties at any time. And we're going to alternate starting first. So last time we started with Mr. Saltzman and Mr. Bennett. So Mr. Abeles and Mr. Doggett, would you please
Certainly.
respond
Thank
to
you,
the question?
Regina. I'm going to pass this to Norton in a minute, but just to say one comment, and that I heard at the public hearing, the selectman addressed this issue and said that the federal government clearly acts on its own and will or will not apply its laws as may be. In terms of the law which you said was illegal, I don't know whether that's correct, because I'm not a lawyer, and I'm going to pass the question over to a lawyer here who might throw some more light on the federal state issue. As you know, in the state, it is legal to have medical marijuana. The federal government, it's illegal.
The Commonwealth's regulatory framework is one of the tightest in the country. It contains within it a prescription monitoring program, requirements of child-proof packaging, labeling, testing. This is a comprehensive regulatory framework that fits squarely within the mandates of the August 29, 2013 Department of Justice memorandum on this issue. Massachusetts is not alone in the regulation of medical marijuana. As I mentioned earlier, 23 states and the District of Columbia are going through this process. If the federal government had a particular quarrel or issue, they would advise the governor, they would advise the attorney general, and action would be taken. But the fact is, the federal government's silence since the enactment of the law really signals their acquiescence.
Very good. Mr. Saltzman and Mr. Bennett, would you care to respond?
I would just say that at this point, a few things. One is, I'm not sure if Mr. Arbeliaz is what he considers about Colorado law, but if Colorado law is similar to Massachusetts law, the federal government came in and shut down over 50 RMDs in 2012 because they were within 1,000 feet of schools.
Certainly,
So,
but that was prior to the August 29, 2013 memorandum, so you're basing that on outdated guidelines.
I'm sure that's outdated. We can go back and forth about the memorandum. I'm not sure it's a place and time, but they've certainly continued to enforce the 1,000-foot. Massachusetts has not yet had an RMD opened up to test it. I guess we can wait and see what they do. But just because they haven't come in doesn't mean they won't come in.
They have come in.
Mr.
They have-
Abeles, hold your remarks.
Sure.
They have come in. They have drawn a line in the sand. Everybody knows that they're not enforcing the laws against possession of marijuana. We know that. What they have said they're going to enforce is the schoolyard statute. They have shut down hundreds of dispensaries in 6 different states based on this. And we know that that is happening. And to cite a dispensary within 1,000 feet within the 1,000-foot setback set out by the federal government would be completely irresponsible.
Right, and I also would add that Mr. Vera's letter that he wrote
It was dated
was dated last year. Well
after the
past.
memorandum.
after the memorandum was written. So Mr. Verrett, at that point in time, I can find the letter here. This is dated August 13th, 2013. And, you know, the letter states that our recommendation is the buffer zone should be 1,000 feet. Federal law enforcement community has made it very clear that it will exercise its discretion to enforce federal law. So I think it's pretty clear that at least last year, Mr. Verrett was quite concerned about the federal law.
Very good. Okay, that's the end. Next question.
Thank you. Thank you to both sides for your presentations. I'm trying very hard to understand this with an open mind. The question that I have is, the proposed site of Brookline Bank is at a major intersection. I mean, heavy traffic in all directions. I'm wondering why the people who are proposing the medical marijuana dispensary are not considering the other site that the proponents of the article have identified. And I have to say, the term disingenuous was used, and I have to say it sounds a little disingenuous to me. If someone is going to be making $3 million plus a month, that you said that the security at Brookline Bank was already so good. Seems to me, if someone's making more than $3 million a month, you can afford to put in good security at another site. So my question is, why are you not considering the other site?
And we'll begin with the Mr. Bennett and Mr. Saltzman.
A good question. I have nothing more to say. I think that the area at Chestnut Hill is far more suitable. It's a large office building. Well, there's many large office buildings out there. There's adequate parking. It's not a single-use building, so that patients who come in won't be knowing what they're coming in for, and they won't know what people tracking them won't know what they're coming out with. I think it's a far better place for an RMD. Again, there's no perfect place, but it's a far better location than the current proposal of Brookline Village.
I would also just like to add that everybody should know this is not really about the Brookline Bank building, because the Brookline Bank building is covered by a 3-year zoning freeze. So whatever happens with warrant Article 12 has zero impact on the Brookline Bank building. So we're doing this for the rest of Brookline. The Brookline Bank building is covered under an A&R zoning freeze for 3 years. Just want to be clear about that.
Very good. Okay.
Madam Moderator, I
2 minutes.
certainly disagree with this issue. This is about the Brookline Bank building, and let the residents of Brookline know that we have thoroughly and carefully reviewed many, many sites in town.
I'd like you to answer the question, why are you not considering the other site?
We have considered all the sites. We chose this site based on reliance on the current zoning bylaw that was passed last year. We have had security consultants and parking consultants, traffic consultants look at it, and in our estimation, this absolutely is the best site in town. And to speak to the traffic issue, Town Member Dodgen.
Thank you, Norton. The traffic issue, we have to bear in mind that that has been a bank for many years. It's defunct now, but when I consulted with traffic engineers, Howard Stein Hudson in this case, who I know quite well, they reviewed my numbers. I did an analysis, and basically what they told me is numbers for the bank are essentially an RMD is 1/3 less traffic than a bank. We've got 767 daily visits, if you want to know the numbers, whereas with their full rollout, with all of these numbers that Mr. Saltzman put up earlier, all of those allow for about 500 patient visits per day for the RMD and about 770 customers visiting the bank. So in terms of, if you look at terms of traffic, that turns into about 500 cars for the bank and much less for the RMD. And what is interesting is Route 9 has, according to Mass DOT, about 32,000 cars running up and down it in Brookline during the day. And that represents probably about a little less than 3% for the bank and 2% for the RMD. So in terms of traffic, it looks like the RMD is in fact more akin to a pharmacy or something of that kind rather than a bank, which is very high traffic.
Thank you.
The traffic.
Next question? If you could speak into the mic.
Because this is not a pharmacy, when a person enters the dispensary and they give the person a script, what exactly happens then? What happens to the script? And what if 2 days later they decide they want to go to another dispensary? Is there anybody or anything tracking these people?
Thank you for your question. That's a wonderful question. The answer is yes. This is about a tightly controlled regulatory framework. There is a real-time monitoring program. Patients are limited to a 60-day supply of around 10 ounces. So they cannot buy more than that in 60 days. There will be a real-time monitoring regardless of where the particular patient goes. They are still, being tracked in real time in terms of the amounts that they purchase. The goal there, of course, is to limit diversion.
If I just add on the real-time monitoring system, that the DPH and the Department of Public Health and the police or the law enforcement have access to that database, and clearly what they'll be looking for is abuse of the system by patients and, of course, doctor prescription mills.
Well, would it surprise you to know that there's a doctor currently in Dorchester that is offering $200 to write a script for medical marijuana? No questions asked?
I've seen that story reported on Channel 5. Whether that's still true, this was when the paper system was involved. The online system, which is now required for all physicians to enter into, has just come online 2 weeks ago.
The bottom line here is that this is a thoroughly controlled system. The Department of Public Health has issued a set of very comprehensive regulations, and it is, of course, our intent to follow not only the letter of the law, but the spirit of the law, which is safe legal access for qualified patients.
Do we get to a chance to respond?
Yes.
So a few things. One, in 2013, there were 108,000 card holders in Colorado, 108,000. 12 doctors wrote half of the prescriptions, right? So same requirement for a bona fide physician-patient relationship that Massachusetts has, right? And NEDA's own projections, the DPH's projections, all are 2% for the Massachusetts, from what we'll expect to see here. So I don't see why we can expect to see very much different. Secondly, 10 ounces of marijuana is a lot of marijuana. To give you an idea, the potency of marijuana has at least quadrupled, if not gone up by a factor of 10 in the last 30 or 40 years. Even assuming 10% potency, 10 ounces of marijuana generates 2,800 10 milligram prescriptions. If you go to the Mayo Clinic website and look at ALS and what they recommend for a dosage, they say a 10 milligram prescription once a day for 2 weeks. That 10 ounce supply supplies you with 2,800 for a 2-month supply, right? Third, the price of, as a business policy, NEDA sells marijuana below street price as a business policy, right? Current street price, I checked it today, there's a website, weedprice.com, for Boston, is $400 an ounce for high quality marijuana. NEDA's business policy is $300 an ounce, right? So there's enormous risk of diversion, even if it is, and I will grant it is safely tracked by the Mass DPH.
I would just like to add that there's also similar rumors about doctors in Worcester that I'm aware of. And we don't know how Massachusetts is going to be able to monitor this. We have no idea. Whether that system works, we have no idea.
Thank you very much. Next question.
Hi. First of all, I'm very, very proud to live in a town that's about to open a medical marijuana dispensary. I think it's great, and I appreciate you being here. Second of all, I want to say, with all due respect, that the federal government has enacted a war on drugs that has been a complete and utter disaster, and the states right now are changing every aspect of how the federal government handles its drug policy. My specific question is, every time I come to one of these meetings, buffer zones are not discussed. Everything about doctors and fake scripts is discussed, and by the way, the Massachusetts state legislature learned beautiful lessons from mistakes made in Colorado. There's remarkable penalties in place for doctors writing fake scripts. My question is there any study that you can quote that talks about the safety achieved through buffer zone legislation? What difference does it make if children are 1,000 feet, 500 feet, 100 feet from a dispensary. I have a two-part question. Literally, could you quote some studies to me about the schoolyard statute's effectiveness? And secondly, could you please compare the effectiveness of buffer zones with the effectiveness of targeted legislation to keep drugs out of the hands of children, to keep the areas around dispensaries safe? If you care about public safety, which we all do, if you care about children's safety, which we all do, what is the best way to ensure the safety of the community? Is it through buffer zones?
And aptly, we begin with Mr. Saltzman and Mr. Bennett.
I would say there are numerous studies of liquor stores' proximity and use. In dispensaries, there are a new phenomenon. I will say, as you very well know, because we both grew up together in Brookline, I lived in this town, went to high school in this town, went to elementary school in this town, and I was a finger-tapping kid outside of liquor stores, right? That happens. It's around availability, proximity, the likelihood of it being diverted grows up dramatically. If you place it in an area where there's lots of
A
kids...
study, just a study, Gordon. Can you tell me about a study?
I can, if you would like, I provide you plenty of studies about alcohol, liquor store proximity and use. Yes, there are numerous studies on that.
But there aren't buffer zones around liquor stores.
I'm saying analogously, if you can get access to a liquor store, analogous to people who desire to use drugs, you can get access to the place where they have the drug, and you will go there. And the closer that is physically to you, the more likely you are to be there. And if you can move it to a place, and in my experience growing up in Brookline, going out to Chestnut Hill was a long, long, long way away. Very different than walking from the high school and to Brookline Village. Right? That's very close. In fact, you wouldn't have to go that close because dealers wouldn't even allow you. You can meet them in Emerson Garden, or you can meet them in Boyle Street Park. You wouldn't have to even make it there.
This is about daycares, right? This warrant article is about buffer zones.
You asked
related
about
to
buffer
daycare.
zones, about why you want to move it away, and that's why you want to move it away.
And there's no buffer zones around liquor stores because there are liquor stores everywhere. There's like 1,000 of them in this area. So the impact of a liquor store is absolutely infinitesimal. The dispensary that's going to go in Brookline is going to be a regional dispensary that is going to serve hundreds of thousands of people. That's the difference. It's very important. Of course there's no buffer zones around liquor stores. They're mom and pop shops that serve the local area.
Thank you very much. Please.
Madam Moderator, let me just address this regional dispensary issue. That is absolutely false. As we know, our neighbors in Newton have just issued a license for a registered marijuana dispensary. Quincy will open a registered marijuana dispensary. Just this last weekend, we heard there is one under works in downtown Boston as well. This issue of the regional dispensary is I don't want to say fear-mongering, but it certainly looks a little bit that way. Here's the other piece of it. We are a vertically integrated operation. What that means is that we have to produce 100% of what we sell. We can't supply medical cannabis for hundreds of thousands of people. We are limited by how much we can produce, and those numbers are anywhere between 4,000 to 5,000 patients right now. So this issue of the regional dispensary really belies a fundamental misunderstanding of what we're doing here. This is medicine, not vice.
I think the question is an excellent one, and I think it's answered actually by the Brookline Advisory Council on Health, which met in their public hearing, and they concluded that there is no evidence that an RMB poses any risk to preschool children, and in fact they asked the proponents for that evidence, but none was offered.
Thank you.
And what we do know in terms of studies, that the Center for Disease Control last year issued the following analysis of teen use rates in states that have comprehensive regulatory framework. Teen use of cannabis actually goes down. This is about control. The word isn't, a free-for-all. This is about a tight set of regulations that are going to responsibly and transparently deal with problems that may arise.
Thank
Hi. My question actually is about tight control. As a physician, I have seen the tight control of other drugs in this Commonwealth, which has led to an enormous problem. What everybody says is tight control has holes all over it, and we have a huge, enormous narcotics abuse and other drug abuse problem in a state that has tight control, licensing of physicians, monitoring of all narcotics, et cetera, and yet there is still enormous diversion and other problems. So I hear what you're saying. I've certainly looked at the state's sign-up. There's no educational component really involved with the sign-up, and I am questioning your comments about the fact that this is so tightly controlled. The feds control narcotics way tighter than the state controls anything, and yet there's still an enormous loss. And you tell me that you only have the ability to make about 4,000 product in your production site, so you could never expand. But I still don't understand why next year or the year after you can't expand your building. I know you're only allowed one building, but why can't you expand it next year and make more and more and more product for whoever? Could you just answer that?
Thank you very much for your
Thank
question.
you, and yes, we will begin with
Madam Moderator,
Mr. Abellison.
on the educational piece, it is a part of the regulatory framework that physicians take continuing medical education credits in order to be able to recommend and not prescribe. And we were talking earlier about studies. Well, very recently, the Journal of the American Medical Association reported that in states that regulate medical marijuana, opiate overdoses go down by 25%. This is really a more comprehensive approach to drug policy. It is about harm reduction, and ultimately, the one word that we haven't mentioned throughout this discussion has been patience. There are people today in our communities, and many of us know them, our cousins, our brothers, our family members that are suffering and that would try and find tremendous benefit from medical marijuana. Our goal is to take them out of the shadows and into the light, to control it, to regulate it, to do it responsibly, and not to have them have to go to the black market and get product which is contaminated, which is not tested. Ultimately, this really is about taking a realistic approach to the regulation of this substance. The market for cannabis, and another point of disagreement with the petitioners, is street cannabis. This isn't about street cannabis. This is about pharmaceutical grade medical cannabis products. There is salves, tinctures, pills, sublingual sprays. This isn't just about, flower and smoking anymore. This really is about opening up this, field of medicine for those in our community who need it. So certainly, will there be problems? Will there be abuse? As you say, there is in every field of human endeavor, but it is our job as a community. It is the Department of Health's job. It is the governor's job. It is our legislature's job to craft laws to address those problems. But ultimately, what we do know is that 75% of Brookline supports regulated access to medical marijuana, and warrant Article 12 is a de facto ban.
Thank you. Mr. Saltzman and Mr. Bennett, 2 minutes.
First, I just want to say, it's not a de facto ban. I'm trying to understand where that's coming from, because we just showed you 2 places where this can go.
With hundreds of thousands, 275,000 square feet of space. The Newton RMD has 1,800 square feet, right? So we've gone from 1,800 square feet for the Newton RMD to 5,000 at the original proposal at Quarry Hill to 10,000 square feet now at the Brookline Bank Building. So let's get an idea about what we're talking about here. The number of critically ill patients, or patients likely for Brookline residents, is 2% of Brookline's population, or 1,200 patients. Now those numbers are 4,000. So when he says it's not regional, it's not true. It is regional. And that is if all 10 RMDs proposed for the metropolitan area, the 2.25 million people in the metropolitan area, get rolled out. Right now, there's one in Boston and there's one in Newton, right? So there is adequate access right now for patients. It's not a question of not having critically ill, helping critically ill. Let's get a sense about that. Secondly, we heard that NETA only can purchase, sell the marijuana they grow in their factory. That's factually not correct. They can purchase 30% from other suppliers if you look in the DPH regs. It's right there. So it's not simply what they can grow themselves. If there's excessive demand, because there's many customers who want to come and buy marijuana to help them, they have an adequate outlet to provide get more medical marijuana from other providers in the state.
I also would just like to add that there was a reference a minute ago that the patients haven't been mentioned, and actually I mentioned the patients. We support these patients as much as anybody. That's what we're trying to do. We're trying to get a dispensary that can open up and stay open and provide for the needs of the people that need it. That's what we want. And for him to suggest that it hasn't been said, I mentioned it right at the beginning.
Yeah, I also would add one final thing. The framework, right now, everything are words on a sheet of paper. We do not know if the state is going to provide adequate resources to enforce the standards.
Thank you, Mr. Bennett. Next question.
Hi. I just wanted to know, why do you think that so many committees have voted unanimously or nearly unanimously against Article 12?
And again, both sides can answer, and we'll start with Mr. Bennett and Mr. Salzman.
I can answer, I think, on two different reasons, I think. One is the very people who proposed the zoning that we currently have in Brookline are the people that are part of the zoning committees we keep seeing. Right? And I don't think it's that easy for them to revisit a topic that they visited last year. Secondly, there are very many people that you keep seeing on the same committees. So the same person who makes the same argument on one committee, you see them again in the second committee, and you hear the same argument. So I'm not sure it's actually a fair, independent hearing at each of the committee meetings that we've been to.
And I think it's difficult for us. We're trying to get information out there. It's difficult for us to do that. We're up against professionals who are making their case quite well. But the facts are with us. It's a tough battle. We've had a lot of support. The support, you're right, is not coming from the town's boards and commissions. But there are people, a lot of people in Brookline that support what we're doing.
The town, as you may recall in the petition ballot initiative a couple of years ago, voted 72%, I think, in favor of having medical marijuana legalized, and then that means public dispensaries in the environment, in the communities. And on this issue of Warrant Article 12, which we're discussing, I think the lady earlier who questioned why are we not talking about the buffer zone, which is what the article in fact is about. When this comes in front of the committees, there has been no credible evidence presented whatsoever that this is injurious to preschool daycare children. They have their own private, if you will, bubble of adult supervision, which provides them a personal buffer zone. And all of the committees have concluded that they're basically that this will impact severely the positioning or the ability for anyone, Netta or any other operator, to put a dispensary in the town. I'm going to pass my minute over to Norton.
I have been incredibly impressed by the level of analysis, by the intelligence of town officials, by the thoughtful and thorough process that has gone on in the town. Planning Committee, Advisory Council on Public Health, Zoning Bylaws, Board of Selectmen, Advisory Committee, Economic Development Advisory Board. They all have found that this warrant Article 12 is without merit. Now, we understand that there will be, and there will always be, on these controversial issues, a minority of individuals that hold a particular view, but we will be good neighbors, we will work with the community. We, too, want to see a safer and healthier Brookline.
Thank you very much. Next question.
I know one of the issues that's been raised in this whole discussion is that there's going to be a lot of money running around on the street because these dispensaries are 100% cash businesses. I'd like to hear you speak to that from both sides. I don't believe that's accurate, and I'd like to see what's the actual situation about this issue, which is, we know this is going to be a new thing. New things are troublesome. There are always going to be things to work out, but I think I'd like to sort of have that one addressed because it's one of the issues that scares people a lot of cash running around as people pick up their medical marijuana.
Thank you for your question, and we begin with Mr. Doggett and Mr. Arbelas.
Let me be very, very clear for the record. Netta will accept debit, credit cards, and checks. We have a bank account, and it really shows the evolution of this issue, even in terms of the federal government. They issued another memo, a memo to banks, and it said you may work with lawful medical marijuana companies as long as they're licensed and as long as you follow the banking protocols that we suggest. We will not be an all-cash facility. We will accept debit cards. We will accept credit cards. And in fact, you're absolutely right. This is something new, and it will take time, but this really falls into a broader narrative. When we talk about reproductive rights, when we talk about treatment of people with HIV, when we talk about now this new public health challenge, which is medical marijuana and weaning people away from more dangerous and fatal narcotics. We will apply best industry practices. I am really, really proud of the team that Netta has assembled, people with decades of experience in public health, people who have made a life's work of offering these new options in controversial options, I might add, for those individuals that need it. We will not be a cash-only facility. That, much like the petitioner's reliance on a federal argument for 2012, is outdated, and certainly not where the regulation of this is, either on a state or federal level.
Very good. Mr. Saltzman and Mr. Bennett, 2 minutes.
I did not hear Mr. Abrelias tell you what % of the transactions would be in cash. I did hear Mr. Verad earlier in discussion say 50% would be in cash. I do know that debit cards are a possibility, certainly checks. Credit cards are more problematic. I know Mr. Verad comes from a company that works in credit cards. Mr. Kessler made his money in credit cards, and possibly there's a way that they're trying to integrate credit cards into the system.
I'd like to take a point of privilege on that.
I'm
sorry. I have to take a point of personal
You'll
privilege.
have a chance to respond with the next question.
I do know that at this point, no major credit card companies will open up an account with the medical marijuana industry because it's still illegal at the federal level, and they don't want to put their banking license in jeopardy. So,
Have you heard about the state banks? Because state banks, I understand, are now starting to issue credit to, and therefore avoid the federal problems. Have you heard about that?
I said no national credit card companies
Okay,
at
but
this point.
have you heard about the state ones?
There are
yourself?
certainly banks that deal and take deposits. There's a concern about what the deposits are for, and they have to go through the same money laundering that any other institution has to go through.
If I could just say, we know there's going to be a large amount of cash, whether it's 50% of the business in cash, which is what's been said. We never said 100%.
We never did.
If it's 50%, it's an enormous amount of cash. That's a lot of cash. There's a lot of drugs. And we know as a society that where there's a lot of cash and there's a lot of drugs, things happen. We're not saying that everybody that goes into this building is a criminal. We're not saying that there's going to be crime everywhere. We're saying that because of the scope of the operation, because there will be an enormous amount of cash, an enormous amount of drugs, we need to be careful. That's what we're saying. I also, I will say I take great offense to being compared to somebody who would fight against HIV patients back in the 80s. I mean, this is the kind of thing that I'm talking about. We're trying to protect Brookline from essentially what we see as an oversized development. These battles are fought in Brookline all the time. It's a tight community. There's very little space, and that's what this is about. And to compare us to people who don't want people to get the help that they need, that we want them to not be able to get their medicine, it's just crazy. And I take great offense to
I
it.
was confused what you said about criminals going in to get their
Ma'am,
marijuana.
as I said,
medical
what we
marijuana?
know by Netta's own estimates, at a public meeting in the
You just
Brookline
said
Bank
something
building.
about criminals going in, and I just didn't understand that
If
part of your answer.
If you would let me finish, I'm going to address that. We know that there is going to be a significant % of diversion.
Mr. Saltzman?
I'm sorry, but I'm not,
No,
she's asked questions.
Hold on just a minute, because I want to be fair to both sides. There's obviously an interest in responding. Suppose for the two of you, I give you 1 more minute, and then you get 1 minute. Would that be acceptable to the two of you?
Sure.
Very good.
That's fine.
You've got 1 more minute to respond, and then you will also have a minute.
Let me finish up. The only thing I will say, the diversion you're talking about, I'll take up the point, but
Yeah.
if there's 18% diversion, that's 18% felonies, right? So
Where does that figure come from? 18%?
That came from
head of
former
Netta.
head of Netta,
No.
who stated that figure at 18% at a meeting on August 5th at the bank building. And he got that estimate by looking at the change in the law and Colorado from medical marijuana to legalization and the drop-off in his sales. And that's what he estimated was the diversion of non-medical use, right? So that's a fact, and we know that that is diversion, and we know actually what's the largest felony in the country? It's drug sales, right? So just because we call it, Massachusetts calls it a felony, it hasn't stopped the largest felony from happening already.
And I just want to emphasize, nobody is suggesting that everybody that walks into a dispensary is a criminal. It's a very small number of people. But when you talk about the scale and the scope of these dispensaries, even a small percentage is a large number.
Are you complete? Very good. 1 minute, Mr. Ellis and Mr.
Madam Moderator, again, where is the zoning discussion here? We are re-arguing the policy arguments surrounding medical marijuana. The voters have spoken clearly
answering the questions.
in Brookline. Thank you for that advice. What we know is that this 18% figure, absolutely out of context, has nothing to do with the discussion here today. Diversion is a crime. We will control against it. The DPH will control against it. And ultimately, it is our responsibility to be partners with the state to have a transparent and comprehensive regulatory framework. In terms of the business itself, this is a not-for-profit. This is a not-for-profit business in the Commonwealth of Massachusetts, and the individual that is the sole funder of this is a philanthropist that works in public health issues around the world, and here in the Boston area generally. This is really comes from a very, very, very good place. We believe we've put together the best team to deal with medical marijuana in Brooklyn.
Thank you, Mr. Ellis.
Hi, thank you for fielding my question. I think we can all agree that we definitely all care about the patients, and I just want to bring them back to the forefront of the discussion. I just want to know what are current options for medicinal marijuana patients in Brookline.
And I'm going to begin with Mr. Doggett. Mr. Ellis.
Excuse me, I didn't hear the question, I'm sorry.
Sure.
It's reverberating off the back, I'm sorry.
Sure. Just what are current options for medicinal marijuana patients in Brookline?
As I understand it, I'm not an expert in this area, but as I understand it, the options for medical marijuana patients today is the street. There are no dispensaries that are currently open. 4 have been licensed to be opened, Newton, Quincy, Brookline, and one in downtown Boston in the immediate vicinity. So in due course, presumably, they will come online, and that will be where a patient can get medical marijuana for the first time, probably sometime next year, I expect.
Really, again, in 2012, the voters authorized safe legal access for those qualified patients that needed it. We're very close to 2015, and that still is not a reality. For us, it's abstract for many of us listening. For the petitioners, it's rather academic, but the fact is there are people suffering today that need access to this less dangerous substance compared to narcotic drugs. So all we can do is work together hand in hand with the community, work with doctors, work with patient groups, work with community groups to be sure that the facility that opens up at the former Brookline Bank building will be best in class. It will be a source of pride for the town. It will be a model of professionalism, of efficiency, and our core values of compliance and patient care will inform every decision that we make.
Thank you.
I just want to say, there's nothing that Warrant Article 12 could do that will affect the Brookline Bank building. The Brookline Bank building is frozen in the zoning. So to answer your question, you heard the answer, and I agree with that. The current state is that you can't buy it. That's the current state.
Actually, the current state is you can grow it. You can get a card, you can grow it. It's legal to grow it right now. I'm sorry, the current state is you can get a card and grow it yourself legally. All right, so at this point, there's been no dispensaries opened up in all of Massachusetts, but you're allowed to grow your own if you have a certificate from somebody.
But it's important to note that Warrant Article 12 has no impact on the Brookline Bank because there is a zoning freeze on it. This is about zoning, and a change in zoning from Warrant Article 12 is not effective at the Brookline Bank site.
Are you complete? Very good. Next question.
I just have 3 fast questions. One, I wondered if you could talk about who you think the kind of client who is coming to the dispensary is, given the experience that we've seen across the country. I mean, what's the typical age? What are the kind of illnesses that people come to? And do you find that you need handicap accessibility? I also wonder if you could talk about this issue, which seems to be, is the Brookline Bank a facility that is, in a sense, off the books, as the warrant article proponents have said? And then I wonder if you could just quickly talk about the issue of security, because that clearly is something that is of importance. What are the security items that are required by the Department of Public Health?
And as with all questions, both parties are going to answer, and we would begin with Mr. Saltzman and Mr. Bennett.
I think that Netta is just more able to answer. These are direct questions about the
I can answer some questions about. I'm sorry. I'll try to speak into the mic. I don't have the Colorado numbers. I have a study here for users of medical marijuana from California. I think they're very similar. Basically, the average age is around 41, 42 years old. 2/3 are men, so you have 50% are less than 40. The uses, less than 10% are of the listed conditions that we all heard about in the ballot question of ALS, glaucoma, cancer. Those comprise less than 10% of the 2%. So basically, the rest are people in various pain. Severe pain, I think, is the category in Colorado. So 90% of the users in Colorado are severe pain, and I think 1% or 2% are cancer, 2%, maybe 1% glaucoma. So the actually listed conditions are a very small portion of the actual users. In terms of, I think your question was security. What was your second question?
The bank.
The bank and security. I mean, that kind of raises the issue of, again, is it a risk? Is the area around an RMD riskier? I mean, there's going to be a guard there. They are saying they need a bank. So in terms of security and concerns about the area, yeah, that's with that amount of cash. Obviously, if you didn't have cash, you wouldn't have a need for a bank per se to lock it away. So there's certainly an issue of making sure that the area around it is safe.
I'd just like to add that, I mean, I don't know, Gordon gave you some specifics about who's going to be going in there. I'm sure you're going to hear more in a minute. But I think it's just important you understand that whoever's going into that building, the vast majority of them need to go in there to get the medicine. And I support that 100%.
Very good.
I'd like to take the A&R question and the relevancy of this warrant article. There is a connection. Basically, the petitioners are well aware that a daycare center is planned to occupy the Boston Interiors building, which is almost adjacent to the bank building, certainly within 100 feet of that building. And the A&R currently, for those that don't know, the A&R filing currently grandfathers the zoning of the bank building for a period of time, 3 years I believe it is, that was passed in last November's town meeting. However, if a 100-foot buffer zone is now adopted, as Article 12 proponents want to do, this opens the door to a legal challenge that could delay the opening of the dispensary for months, years, and possibly not even happen. So I believe that the 100-foot buffer zone is just as problematic as a 500-foot or a 1,000-foot, whatever buffer zone it is, and it's frankly, as everyone has concluded in the committees, not relevant to the safety of the preschool children.
In terms of who the patients will be, it suffices really to look around the room and to walk down Harvard Street and see who's there. It is many of us in our communities. It is grandmothers, it is aunts, it is brothers, it is sisters, it's everybody. The fact is, we are just now beginning to understand how medical cannabis products can many times substitute more deadly alternatives like opiates. So certainly what we encourage is responsible use with heavy oversight. In terms of the security itself, that really is fundamental to the regulated model. It is about controlling the supply chain, understanding what is cultivated, how much is cultivated, and to whom it is being sold. It is about a closed loop of production and distribution. There will be cameras, there will be motion detectors, there will be state-of-the-art security, which is part and parcel of the state regulation. And certainly, we will work diligently with town officials, with Police Chief O'Leary, who was here earlier, to ensure the safest dispensary in the state.
Thank you, Mr. Arbelis. Great, next question.
Good evening. Thank you for fielding my question. I have one question and 2 points of fact about, this is to the point of the gentleman's question about where do people get their cannabis now. You cannot grow cannabis if you have a card here in Massachusetts. The DPH took that away. You can really only get it from the street right now. You can also get it from a caregiver, but the caregiver is only allowed 1 client. And the other point of fact is to the federal laws and to sort of some of the federal things that are going on with cannabis. The federal government owns patents on cannabinoids. Those are some of the health benefits from using cannabis. And the University of Mississippi grows tons and tons of cannabis every year, and they do studies on it there. And the federal government has allowed, I can't remember the name of the company that's going to do it, but has allowed a company, maybe Norton can speak to this, doing a test on PTSD. So the federal government is studying it with PTSD, which is, I think, really important.
Question that you have?
Yeah, my question is, why have there been so many changes in Article 12 since you guys brought it?
Okay, very good. And we will begin with Mr. Arbelis and Mr. Doggett.
For us, it really boils down to the only constant in warrant Article 12 is the Brookline Bank building. And, you know, there was a letter recently that was submitted to the TAB saying that this really is an exercise in NIMBYism. I don't know. I can't really speak to that. All that I do know is that this particular building, we've looked at it every which way in terms of security, in terms of public transportation, in terms of access. This is one of the safest locations in town. Go ahead.
Why so many changes in Article 12? I don't really know that. The question really goes to the proponents, but in terms of what I'm hearing and have heard at the many public meetings that I've attended and participated in terms of committees, I'm concerned that the kinds of problems that have been described here tonight by the proponents and throughout the meetings are in fact, no matter where you cite this dispensary in Brookline, whether it's in Chestnut Hill, whether it's in Coolidge Corner, whether it's in Washington Square, it's going to have the same problems as were described. And if they're so bad, I don't understand why Brookline, it seems to me that the proponents really do not want medical marijuana in Brookline. That's my observation.
Not true.
Again, we just keep hearing the same refrain that we don't support medical marijuana. We're hearing so much misinformation, it's kind of hard for me to know where to begin. First of all, so we're not moving a warrant article that has a 100-foot buffer. It's 500 feet from daycares.
And it was never our intention of the 100 feet. That came out of a subcommittee, which we had no control over.
Right,
That wasn't our number.
To answer the question, the reason that there have been changes, this is incredibly common in Brookline. When warrant articles work their way through the process, you go through so many different meetings with so many different committees, and it really gets out of your control. People on the committees will make amendments. They'll move amendments. That's what happened. This was not something that we suggested. This was something that the changes that have happened have come from other members of committees. It's incredibly common for warrant articles, by the time they make it to town meeting, to be amended. I don't know what the statistics are, but I think a huge number.
And I would add this, that when we initially started, we had the language, the state language facility in which children commonly congregate, and that language, as interpreted by the town, blacked out the whole town. And that's not what we wanted. We wanted one in Brookline. And so we changed and modified the language to make sure that there were locations in Brookline.
And we just keep hearing again and again that, we're just up here secretly plotting to get it out of Brookline, that we don't want medical marijuana, that we don't support these people who need it, and it's unbelievably offensive.
Thanks for answering the question.
Very good, thank you.
Hi. So I was wondering if you could speak to the proximity of the dispensary to the high street housing developments. I know it's kind of been part of the controversy, but given the fact that there's a huge...
Pardon me, could you speak up?
Sorry, everything is echoing. So given the proximity of the dispensary to the high street housing developments and the fact that there's such a huge stigma associated with living in those developments, has anyone actually talked to the people that live there? I just haven't heard anything from the people that are actually, supposedly being affected by it being in that location.
And the response should come first from, is that your question?
Yes.
Yes,
Yeah.
very good. Okay, Mr. Saltzman and Mr. Bennett first to answer.
Well, we have a petitioner who actually grew up in the housing project and speaks to it. And also, we have contacted, and we have been contacted by a lady there who will speak to it. So yes, they are profoundly concerned of the proximity of the housing project to the RMD. And in fact, under federal law, that is one of the categories of the 1,000-foot setback. So it's not just that they're concerned, it's also a concern in federal law in terms of the proximity.
Sorry, go ahead.
Very good.
I haven't heard of anyone speaking to this point. It's a very good question, by the way. But let me give you an observation that I did. I went and spent an afternoon walking around Brookline Village, walking specifically around the bank building, all around 500 feet, 1,000 feet in all directions. And I also stood on the corner for an hour counting pedestrians and wondering what the composition was, because I'd heard in public meetings that there was a concern about children passing by the building. There are children passing by the building. In fact, I counted 40 between 2:30 and 3:30. You see, I'm not for numbers. And they're mainly older teenagers. All of the children under 8 were in hand, usually hand by hand with an adult, or pushing in a pram or whatever. So those certainly were supervised. But my observation is this: that if the town the NETA goes through the process, and the Zoning Board of Appeals, the Board of Selectmen have to grant a license, I would like to see a security guard on those front steps, because when I was sitting across, I just felt that would be for two good things, by the way. One, for the building itself and what it contains, but more importantly, the uniform presence of an adult on that corner would have a tremendous beneficial effect on what I saw as some somewhat reckless behavior coming across Route 9 and Washington Street, to be quite honest. There was no crossing guard there, by the way, on the day that I was observing. So I think that would be a real benefit, and that's something which the licensing process can address, and the selectmen can authorize that, I'm sure. Maybe you'd like to comment more.
We certainly do support the idea of a security guard. If the selectmen and if the town feels that that's what we need to do, we're more than willing to do that and pay for it. There has been a lot of changes in Warrant Article 12, but in all their iterations and throughout this long process, every committee and every group of town officials that has looked at it and studied it and spent hours in public comment has come to the same conclusion. Vote no action on Warrant Article 12.
Thank you, Arabellas. All right. One more.
I just wonder yeah, after everybody's been warned about this, how would you feel about the kind of regulation that it seems to be coming out of Newton, with selling maybe 1 ounce at the dispensary, and then the remainder, the other 9 ounces or whatever the supply would have to be transported by your organization to the individual patient's home?
And we will begin with Mr. Arbelis and Mr. Doggett.
Madam Moderator, thank you. We really want to tailor a solution that is specific to Brookline. The fact is that the delivery model has a host of problems. First of all, for those individuals, for those veterans that live in public housing, for those veterans that, really exist because of federal government and subsidies, we could not deliver to them in those federally subsidized housing. It'd be very, very difficult to do that. The security aspect of delivery is very specific as well, the protocols that are required. So definitely, we want to consider all options, but after having looked at it, particularly because we will shy away from cash, we will allow debit cards and credit cards. It's a very, very different situation from that of Newton, and we want to tailor a solution that is a Brookline solution that is specific to the needs and realities of town and not of Newton.
I just would, if I could, a couple of seconds, just to add, coming back to the Board of Selectmen special licensing process that's required, and I think that this is something which I'd like to see them discuss with NEDA when they go through their application process, and I think that the Newton model or variant of it certainly would be beneficial. I think that clearly delivery is good for getting traffic off the street and reducing the amount of marijuana being handled essentially by the patient. So I think that's something which we should encourage the Board of Selectmen to take up in the licensing process.
Yep, please, Mr.
Okay,
Saltzman and Mr. Benefit, 2 minutes.
I'll just start, maybe Dan can complete. I would say a couple things. 1 ounce of marijuana, again, in terms of dosages, is 280 10-milligram dosages, right? It's a lot of marijuana. NEDA's numbers suggest that an average patient uses 1.6 ounces a month and visits 2.5 times a month. So when you do the math, you're getting 0.64 ounces per visit. So 1 ounce should be sufficient if people want to buy more. That is already more than an average purchase. We, of course, in terms of minimizing community impact, an appointment-only model would help, and we would support that in terms of reducing issues for the neighborhood. And we would also, I think, again, would like to see Newton's model of limiting the amount of in-store purchases. In fact, we would prefer, and maybe it's not possible, but a 100% delivery model with a store that patients can go into and view the products, learn about the products, order the products, but not walk out with the products and have them delivered, would be a much better model for our community. Again, in terms of tailoring a dense community, unlike Newton where there's more openness, we live on top of each other, right? And that would be a much better approach given Brookline's unique conditions. I think we could go even further than maybe what Newton's done.
Yeah, we support delivery, and when the question comes up, we don't really get a straight answer as to why the Newton model, which as Gordon just alluded to, would actually work really well in Brookline. We would support that completely, having less marijuana coming out of people from the dispensary, as was suggested by the gentleman next to me. That's what we want. That would be perfect. And I don't understand why the Newton model is not what is being proposed for Brookline.
Thank you. No more questions from the floor? Then we'll move to closing arguments, and the opponents of the warrant are invited to go first. So please, you have 3 minutes between you.
Okay, I will take the 3 minutes. Last November, town meeting passed a well-considered R&D zoning regulation with 500-foot buffer zones around all the schools. Article 12 proposes to create additional buffer zones around the 89 daycare centers in town, which would not only rule out the Brookline Bank building as a possible location for an R&D, but make finding any location in town almost impossible. The proponents have asserted but provided no evidence that preschool children who are always accompanied by an adult need some sort of buffer zone. The Brookline Advisory Council on Health, as I mentioned earlier, concluded there was no evidence that an R&D poses any risk to preschool children. The advisory committee discussed this at length and considered the pros and cons of both a 500-foot buffer and a 100-foot buffer, and they voted against both of those options. It was considered unnecessary because in reality would provide no additional protection for street coolers. I mean, this is a recurring theme. Fears that the RMD will be overwhelmed with patients and traffic from Boston and beyond have been overblown. Firstly, the patient population will be divided between several dispensaries. 3 dispensaries already been mentioned, Quincy, Newton, etc., and there are more in the pipeline. Certainly there'll be another one opening up in Suffolk County now that Mayor Walsh is on board. We have the strictest patient eligibility in any of the states in terms of condition, what's called the debilitating condition, which is defined here as progressing to such an extent that one or more of a patient's major life activities is substantially limited. That's a very high bar for getting a certificate. And I would submit to you, we're not going to be anywhere near the 2.1% of IDs issued, which is the Colorado figure, which is an outlier of 16 states, which we have here that I surveyed. We are going to be, and the national average, by the way, is 1%, and most of the states are well below 1%. Arizona, our size, 6.6 million, is 0.4%, and they've had the program in for 4 years. So it's just not going to be the overwhelming explosion. There's a database tracking system that we've covered, which is going to basically record all certificates and IDs that are issued by physicians, and this tracking database is accessible to law enforcement. The traffic I covered, basically, there will be about 500 patients a day on Netta's high demand estimates, which is 1/3 less than the daily customer visiting the original bank. The proponents, I want to hit this point again on the ANR filing. The daycare center is going in, perhaps onto Route 9 on the Boston interiors, and the ANR filing currently grandfathers that zoning, that zoning of the bank building that was passed in last November's town meeting. However, if the 100-foot zone is now adopted by passing Article 12, this will open up a legal opportunity to put this into the courts, and we'll probably never see an RMD in Brookline. To reiterate, no committee has found any evidence or reason that a daycare buffer zone adds any protection to preschoolers that they don't already have. The zoning changes demanded by Article 12 is not the appropriate way to ensure that the community's legitimate concerns are addressed.
Thank you, Mr.
And I
Doggett.
conclude, thank you.
Okay, very good. Mr. Salzman and Mr. Bennett, 3 minutes.
Yeah, if we could get the presentation back up, but first of all, I want to say we are not moving a warrant article with a 100-foot buffer zone. I just want to be clear about that. It keeps being repeated, but that's not what is going to be moved at town meeting. So what we have here is the vision that was reproduced for everybody in what's called the combined reports a year ago. For those of you who don't know what the combined reports are, it's kind of like the guide to town meeting. So people, the town meeting members go in, they have this sort of the Bible of town meeting, and they read different opinions. And what you have up here is the vision by a very prominent committee in Brookline about, oh, there it is, even better. The zoning bylaw committee was guided by a vision, and we're talking about for the RMDs, of an RMD that operated as a nondescript office within a larger building, possibly a medical office building, and that has no direct access to the street. The state regulations also limit signs and other visible evidence of an RMD. Others may be concerned that an RMD will look like head shops from the 1970s or will be prominent freestanding buildings such as the Brookline Bank building in Brookline Village. 1 year ago, this is what we had as an example of what would not be appropriate for the siting of an RMD. That's what we voted on. Not me, again, I'm not a town meeting member, but that's what was supported. That's what was in the combined reports. So now what we have here is a letter to Brookline. Again, this was about a year and a couple of months ago. We have adopted as a strict standard of care that we will not locate an RMD within 1,000 feet of a school, even if zoning allows it. We bring this, the current federal enforcement guidelines, we bring this to your attention because we want you to attract to Brookline the most high quality, experienced, and careful RMD operators. We think only those companies that respect the federal 1,000-foot buffer zone satisfy these important criteria. It goes on, the letter. There will still be locations that meet your other zoning criteria, even with the 1,000-foot buffer zone. We encourage you to amend your proposed bylaw to make the elementary or secondary school buffer zone 1,000 feet. Those quotes come from a letter from about a year ago from the current head of Netta.
And things have changed.
I gather you're complete.
So I will actually continue then with my time. We would love to know, what has changed? What about those words that you see up there could possibly change that would invalidate the words? We think only those companies that respect the federal 1,000-foot buffer zone satisfy these important criteria. What could possibly change that would change the words up on that screen?
A new approach by the federal
I'm sorry, who gets
Mr. Arbolis knows better. Thank you.
That's all. Thank you.
Very
And we
good.
hope that you'll support warrant Article 12.
Nice job. Thank you. And we have one more. Warrant article to discuss. That would be Article 15 on taxi medallions. And if I could have the proponents, John Harris, town meeting member from District 8, and Chad Ellis, also a town meeting member, and then against Fred Levitan and Michael Sandman. Thanks. Thanks.
Yeah, that's not easy to monitor.
I'm sorry.
The woman who asked 3 questions is on the practice of matter. The papers go down and go into the meeting. Wow.
Thank you. The lesson. If we could have some attention to the people who are watching from the home screens. Thank you very much. All right. Good evening. We are here to discuss Article 15 on taxi medallions. And as was noted before, we're going to have opening statements of 5 minutes per side. And proponents open first and close last. So proponents, if you would please choose and split your time appropriately, watch the timekeeper, and stick to your 5 minutes.
Hi, thanks very much for having us for this forum. My name is Chad Ellis. I'm a town meeting member, and I got involved in this 6 months ago at this very forum. The Brookline taxi industry is in a difficult situation. The companies are barely staying afloat. Some of them are in danger of going out of business. And the drivers are not making enough money, and a lot of them are leaving so that we actually have empty cars that are licensed but are not driving. They're also facing a period of real disruption and change. We all know about services like Uber and Lyft, but there are other demographic and technological changes that challenge the industry. So fortunately, we have a solution that addresses these problems. To deal with the rapid change, our solution is going to make change virtually impossible by locking us into a very rigid system. And because low profitability is one of the difficulties, we're going to impose some new costs on the industry and not eliminate any costs. Now, if this sounds a bit odd, it's not you. Normally, when we look for solutions, we don't pick ones that exacerbate the problems that we're trying to solve. But that's the kind of solution that taxi medallions offer. Medallions take a business that's struggling and adds a permanent cost. It takes a business that is facing massive change and locks us in on a path that we have to choose now. Now, Mike and Frank will point out that the taxi operators want to have medallions, the town will make money from selling medallions, and a number of drivers are interested in buying them. So how can they be this so bad if so many people want them? To understand that, we need to think about how medallions work. A medallion grants permanent ownership over the taxi industry. So it represents all the value that will be earned forever in the taxi industry and brings it forward right now. Most of this value will be earned by people who are not even in the business now. It's going to be earned a long time into the future. This is why there's always been 2 groups that really like medallions and find them attractive. The current operators who get to buy them at a lower than market price and sell them for a large windfall later on, and the current government which gets to share in this wealth. And this is what we're seeing here. The taxi companies stand to make a substantial amount of money, which is very attractive to them. And when you hear about it from the town's perspective, the one thing that keeps being appealing is we could make a lot of money off of this. Now, I was on the Override Study Committee, and as much as anybody, I appreciate the attraction of a windfall for the town. I would love to provide the town with some money. But you need to balance the revenues or the benefits with the costs. And in this case, the costs are substantial and they're permanent, whereas the windfalls are temporary. The first and simplest cost is financial. So Brookline Bank guesstimates that taxi medallions will settle for somewhere between $150,000 and $200,000 each. Every new entrant will have to pay this money in order to enter the Brookline taxi industry, in addition to any other operating costs that they would have to incur. Now, at today's interest rates, it doesn't seem too bad. You have a 10% down, an interest rate of maybe 5%. It's only $7,000 to $9,000 a year. But remember, this is an industry that is already struggling to hold on. $9,000 a year per car is not small when you measure it against the current industry profits. And at the end of the day, nothing is free. This cost must be paid by someone. It's either going to come out in higher fares, lower wages for drivers, or lower profits for the industry, which currently doesn't have any profits to give up. The second cost is inflexibility. Now, before the Moderators Committee met, the pro-medallion side advocated adopting a plan that had been negotiated over a period of years with the help of a leading consultant, Richard LaCapra. At a meeting earlier this week, Mike acknowledged that the LaCapra plan, which you were asked to support 6 months ago, is dead. The Moderators Committee is unanimous on this point, and with good reason. Now, Mike argues that the LaCapra plan was good when it was written, but that things have changed. I disagree. I think there were problems that were evident back then, and we've identified more during the summer. But let's assume that Mike's right. Let's assume the LaCapra plan was good, but things have changed so much in the past 2 years that now it's dead. Isn't that exactly the point? That committing us to a rigid plan in a time of rapid change is a bad idea? What happens even if we come up with a good plan today? What happens 2 years from now when that good plan deserves to be dead? There are other costs too. By selling medallions, we grant a higher legal standing to the taxi operators. Community after community with medallions has seen higher rates of lawsuits and threats of lawsuits designed to get favorable regulation. At more than half of our committee meetings, being told to stop, I'm going to finish my sentence?
We would prefer you didn't.
I will stop. Perhaps I can address that point during questions.
That's a great idea. Thank you. And Mr. Salmon and Mr. Levitan, 5 minutes, please.
Thank you. Excuse me. I'm Mike Sandman. I've been dealing with the question of taxi medallions for longer than I care to remember, as has my colleague Fred Levitan. And I'm going to speak as quickly as I can, because I have a lot to say, and I'm going to give Fred a little bit of time. There are 182 taxis licensed in Brookline. The licenses are issued for 1 year, and the taxi operator pays a $300 license fee per year for each cab. So the town generates $54,600 a year in license fees. Each taxi generates $700 a week in lease fees from the driver, or $35,000 in gross revenue if the cab is leased out for 50 weeks a year. This sounds like a very good deal for the taxi companies, but a major disadvantage for the company is that they have no right to sell the 1-year license. The owners have no exit, no way to accumulate value in the company that they can sell when they want to retire. About 12 years ago, the companies in the town started discussing taxi medallions. Unlike an annual license, medallions carry with them a permanent property right. The owner can sell it to recover his or her investment as long as the buyer has a clean record. Brookline would get $60,000 to $100,000 per medallion, $10 million or more in total, plus ongoing transfer fees. Why would the owners pay so much? Because they've been renting the right to operate, and now they'd be able to buy that right. Just like a renter preferring to buy a house. They'd have a way to build value and sell it at a later date. Individual drivers get an opportunity to become independent business people by buying a medallion in the initial auction or from an owner. There are at least 40 Brookline cab drivers who have indicated that they want to do this. And the public would get a new cab fleet because the companies would have to put a new fuel-efficient vehicle on the street for each medallion they bought, and the financing mechanism actually gives them a way to capitalize their business a way that they currently don't have so that they could afford to spend the money on those vehicles. Thus, the medallions, on balance, are a good thing for all the interested parties. Not perfect, but a good thing. On its face, it appears that Article 15 simply seeks to prevent the town from issuing taxi medallions. Why do that? Well, medallions limit the total number of cabs on the road, just as our current licensing system does today. The petitioner and his closest supporters believe that the town should open the market to anyone who wants to operate a taxi and abandon a policy that we and most urban municipalities have had in place for decades, which is to limit the number of taxis on the street. At its core, this is a Tea Party argument in a coffee clutch town. It's based on the idea that government can't do anything right and that the open market doesn't do much wrong. So the market should determine the number of taxis in town, just as it determines the number of restaurants. You are the government. If you believe that Brookline government can't get it right, then you should vote for Article 15, either as it stands or as it's likely to be amended. If you believe that regulation by local government makes sense under the right circumstances, you should vote for no action, which would preserve the capability to issue medallions in the future. If you think that regulation can sometimes be a good thing, but you want to step back from issuing medallions and have the Transportation Board rework the plan designed by the town's consultant, that's a different outcome. For that outcome, you should vote in favor of Article 16, which will send the issue back to the Transportation Board with a broader set of criteria than Mr. LaCapra received.
Very good.
Thank you. I'm Fred Levitan. What Mike didn't tell you was that he's a former chair of the Transportation Board for, I don't know, probably 5 or 6 years anyway. And that before Mike, I was the chair of the Transportation Board. And this issue has been discussed since 1994. It's now 20 years. You hear 10 years, selectmen don't like to think in longer than 10-year terms. But we've actually been talking about taxi cabs for 20 years. When we set out to design a taxi cab system, a medallion system, what we tried to do is protect those people in the town that needed protection and that needed taxi cab service, mostly our elderly. We have a BETS program that gives a discount to the elderly. We wanted to make sure that the BETS program would continue. We wanted to make sure that new cabs could be purchased and that the funds were available to capitalize the industry. The only way that we found to do this is through taxi cab medallions, where they can get a loan from a bank to run a business the way it needs to be run. Thank you.
Very good. Questions from the floor?
I'd ask the proponents and opponents of medallions for the biggest or most important pro of a medallion system and the biggest or most important con or drawback of a medallion system.
And if we could start with Mr. Salmon and Mr. Levitan.
I think the biggest pro would be the capitalization of the system, allowing new cabs to come onto the road and to have better facilities for Brookline residents to ride in. I think that's the most important.
I think that I agree that is the most important. I'd like to give you the second most important, however, which is an opportunity for individual drivers, not all of them by any means. We have something like 400 licensed Hackney drivers in Brookline, but some significant number of them to become independent business people. And there's been some discussion about whether that's a safe thing for people who are largely from an immigrant community, and some of them have an accent and so forth. Frankly, I find that to be condescending, bordering, I'll say it, bordering on racism.
It is racism.
Yeah, these are people who know their business very well, and they are very interested in entering into a medallion system because they see that it's a way to liberate themselves from having to pay the companies $35,000 a year off the top in order to drive a taxi.
Sorry, respectfully, I asked for a pro and a con, and I heard 2 pros. So I'd like a con, please.
Oh, I beg your pardon. I didn't get the con part. The con to medallions is there is an inflexibility
permanent.
that tends to get built in. There's no question about that. Yeah, we accept that point.
Great. Mr. Harris and Mr. Ellis, a pro and a con.
Sure. Well, so I think the pro is fairly straightforward. At meetings like this, it becomes capitalization. But in every public meeting where this has been discussed, the gentlemen to my left have said that money for the town is the biggest pro. I think it's the only real pro that holds up. If your goal is to raise something on the order of $10 million for the town of Brookline, medallions is a path to doing that, and there is no non-medallion path to doing that. So I think that's clearly the biggest pro. I think of the two major cons that flexibility may be bigger than cost, but that's a tough choice.
I would say, for personally, as the son of a small business owner, for me, the biggest con to taxi medallions, and the one that drives me to get involved in this issue, is that taxi medallions would only apply to a single small segment of a single industry that serves the citizens of Brookline. It will not apply, for example, to livery cars, which are you call on your telephone. It will not apply to, say, Uber cars, the cars you call on your smartphone. It will only apply to the cars that you call through a street hail. That's the only thing that a medallion allows a vehicle to do that livery and the app cars cannot do. So it's not, and on top of that, we're only talking about medallionizing that one segment of the ride for hire industry. If we're going to medallionize a private industry that serves the residents of town, let's be consistent. And the health department regulates restaurants. We should medallionize every restaurant in town. The health department regulates daycare centers for health reasons, tattoo parlors for health reasons, whatever. We should medallionize them all. Ultimately, it's ridiculous. The whole idea is ridiculous, and it's completely unfair to target this one small segment of the ride for hire industry in town.
Thank you very much. Next question.
Thank you. So I'm wondering if, specifically to the point of monetizing the system and taking something to the bank, could you not create, rather than an indefinite right or ownership, could you not create a 3-year, 5-year, 10-year mechanism to grant people authority to run taxis and take that to the bank?
And since we use both groups to answer, we're going to begin with Mr. Harris and Mr. Ellis.
Okay. So I think one of the things that we've learned, and this is going to be one of the areas where we agree, is that if you want to have substantial capitalization that you can borrow from a bank, you're really talking about medallions. The issue with a 3-year or 5-year or 10-year license is that because it's not transferable, because you can't sell it to someone else, you don't own the industry, it becomes a small business loan. And small business loans are difficult to get. Not impossible, but difficult. A medallion essentially becomes a $200,000 asset, which our current plan would allow you to buy a $30,000 car. So it's kind of a howitzer to kill a fly, but without the howitzer, the companies would need to come up with the capital on their own. They have said they're not able to do that. I don't think that the taxi industry is magical. I think if we have a system where people can make money, they will find ways to operate.
I would expand on that. Basically, there is a form of property that's absolutely appropriate for this business, and what it is the vehicle itself and the tools that would be used. This is absolutely in line with a number of other other businesses in town. Plumbers, let's say, landscapers, people who have to drive to where they perform their service. They have to buy a vehicle that's comparable to a taxi in price, maybe even more expensive, perhaps because bigger, and also they have to buy the expensive tools of their trade. And by the way, a number of businesses also have annual licenses. Restaurants, beauty parlors, bodegas, et cetera, et cetera. So a one-year license is not at all unusual, and there's no reason why we should be penalizing people in this one segment of the ride for hire industry. They have a legitimate property interest and potential, which is in the vehicle themselves.
Thank you, Mr. Harris. Mr. Salmon and Mr.
We're not penalizing anyone. What we're doing is we're setting up a system that will allow them to operate in perpetuity they'll own their cab, they'll be able to appreciate value in their cab and their business, and they'll be able to work that business and then sell it at some point in time. Without that capitalization, none of this is going to happen. You know, the town is facing a huge override. There's $10 million on the table. People don't want to talk about the money because, you know, that's a bad thing to want that money for the town. Well, you know, it's a good thing. The town needs the dollars. It's going to come from our pockets one way or the other. If it comes out of the taxi cab medallion owners, they amortize that over a 25-year period. They'll pay that out, and the money will come to the town almost immediately.
Can I just follow on to the, Chad is correct in saying that it's difficult to get a small business loan. We had on the taxi medallion, on the Moderators Taxi Medallion Committee, we had somebody from Brookline Bank who has been involved in lending money for taxi medallions in Boston and Cambridge for in excess of 20 years, come and talk to us about that, and he made it very clear that the lending industry understands medallions and that they don't understand 99-year leases or 10-year leases or anything of that sort. He also said that in his 20-plus years of experience, he had never had a situation in which an individual taxi operator, owner-operator, had defaulted. Never in 20 years of experience.
Never had a missed payment.
In fact, he said never had a missed payment. So the industry obviously and the drivers obviously think that this is a good deal for them, even though it does, as Mr. Ellis says, introduce some extra costs, the cost of financing.
One more thing, we're not doing this because we want to do it. We're doing it at the request of the cab companies originally. They came to us and they said, we're in this license system. We can't operate in this license system. It just doesn't work for us.
Thank you, Mr. Levitan.
I think I had a minute here. I think she
Oh,
just
I'm
flashed me a
sorry.
1-minute
I
sign.
misread my timekeeper, thanks.
I'm sorry?
I misread my timekeeper, thank you.
That's fine. We're doing this at the request of the cab companies and at the request of the drivers that are looking to get involved and own a business. This is their only way to do that. They can't, in any other manner, become their owners of their own businesses. Thank you.
Just a quick follow-up, if I could. I still don't understand, I mean, we mentioned the changing environment and long leases and whatnot. Why set it up in perpetuity? If the industry's changing, why not a 5-year medallion or a 10-year medallion? Maybe I'm slow on the uptake. I don't quite understand why a sunset. We have bonds that run for 5 or 10 years.
So I think we'll go ahead and just, since that's really a whole
Thanks,
separate
understand
question, we're going to give 1 minute to each group. So please, Mr. Salmon and Mr. Levitan.
I think it's a good question. The number of the taxis per se are a segment of the ride for hire business or the livery business. Okay, the other portions of the business are unregulated. And while it's true that the industry is changing, in many ways, the industry has been opened up to the free market by Uber. Almost anybody can join Uber. They don't have to pass a background check by the police. They don't have to have insurance checks. Their vehicle doesn't have to be checked. It's wide open. The question is there going to continue to be enough of a market for taxis to justify the number of medallions that we're planning to issue? And the answer to that is there will always be people who want to take a taxi with a regulated rate, a regulated driver, a regulated vehicle. And as I would say about a lot of other innovations, radio wasn't replaced by television. Television hasn't been replaced by the internet. Stop.
So, just to answer the question quickly, you only need medallions if you are looking to create a financial instrument that will recapitalize the industry. And essentially what you're doing is using medallions to capture the value from the future, give some of it to the town, some of it to the industry, which they can use to buy vehicles. The claim that this is the only way that taxi drivers can become owners of their business is simply false. There are a number of communities, including many the size of Brookline, that have what are called open license systems. That is one option in which everyone has the right to operate as long as they are performing to the standards set by the community. That's like any other business. You can operate. It's also the case that even with the 1-year licenses, they are virtually automatically renewed. We have only not renewed licenses in cases of cause in, I think, 20 years. You can correct me if I'm wrong. But the visibility that they have is actually much greater than is being described here. But a 5-year license or 10-year license would also be a way to say you can certainly capture the value of the car that you invest in, and you can build value in your business like anyone else.
Hi, I have more of a process question. When the voters, when town meeting approved the ability of gave the selectmen the ability to issue medallions. It required a process of having to do, it was a home rule petition, one had to go to the legislature for approval and come back to the town. And it's a complicated process. We often go as a town to the legislature for approval, and we don't often get approved.
Right.
But in this case, we actually did, and that was, I think, an important, it was important to the town to have success at the legislature. And I'm just wondering, the way you filed your warrant article was to remove that authority from the Board of Selectmen, which would mean going back to the legislature and asking them another home rule petition saying, sorry, we've changed our mind, don't do it. And I'm just wondering if, just in terms of political capital and the best way to really deal with an issue that you have some legitimate concerns about, I think the conversation has been useful and important to have.
Yeah.
But I'm just wondering whether this was really a best approach, or whether you could have seen another way to maybe get this across.
And appropriately, we're starting with Mr. Harris and Mr.
Yes,
Ellis.
thank you. I am the original petitioner of warrant Article 15, and when we presented the original article to the Board of Selectmen, what was it, 2 weeks or so ago, that was their main concern, and it really, drove home with us. And so basically what we did was work together, and there's a substitute, a revised warrant Article 15 that has now been approved and will be actually on the warrant as a, what's it called, a amendment by substitution is the procedure. And I can read that because it's very brief. Be it resolved that it is the will of the town that the Board of Selectmen not sell, lease, rent, or otherwise make available or require taxi medallions as a condition of any taxi cab owner doing business in Brookline.
So basically, we've taken that away.
It will not require reapplying to the state legislature to remove that authority.
That's a nice change, John.
Thank you.
I'm happy for you. Article 15, just like Article 26 at the last town meeting, asked for us to go to the state legislature like idiots and ask that they remove our right that they granted to us. The advisory committee voted no on both of those articles, on 26 and again on 15 this year, because of that language. We haven't seen this other language. It's nice to hear it.
Hot off the presses.
It hasn't come to the advisory committee. I don't think the selectmen have spoken about it yet, but we're going to town meeting next week, and we don't know anything about it, really. Go ahead, Mike.
However, I will say that
I have not been convinced that it's not the right plan. I think the dollars need to be shifted a little bit. I think that Uber has taken a piece of that business, and we need to be careful on the dollars of what we charge, not to make the cost too high for companies, but I still think it's a good plan.
I think one of the problems with the LaCapra plan, or the primary problem with the LaCapra plan, is the delay that has taken place since the time that it was brought to the selectmen and then directed back to the transportation board so that regulations could be put in place. That delay and the delay, for that matter, of getting to the plan because of the need to negotiate with the companies to work out something that they felt was doable from their perspective. That delay has been a couple of years. And in the meantime, the taxi fleet has deteriorated. The number of drivers who are willing to drive for Uber has increased to the point where the taxi companies are having a difficult time getting drivers at all to drive their clapped-out vehicles. And circumstances have indeed undermined what was at the time a very good plan.
Okay, so I don't want to speak for Fred. I hope I'm not mischaracterizing what you said earlier this week, that you do view the plan as dead now.
As a practical matter, yes.
Okay.
Yeah.
So the description of the plan in terms of the tiers, I think is accurate. The structural problems with the plan, I think, go deeper than something that relates to delays. And to give you an example of one of those structural plans, it envisioned allocating medallions on a pro rata basis according to licenses that currently exist. But some of the Brookline taxi companies, in particular Bay State, have a substantial part of their business that is outside the Brookline regulatory framework. And what we learned during open meeting conversations was that the largest taxi companies were substantially looking at this plan as a way not to reinvigorate and reinvest in the Brookline taxi industry, but to exit the Brookline taxi industry to large extent. And in the case of companies that had businesses that were built up, which all credit to them for building them up, but that were built up outside, they would sell the medallions that would normally be used to service that business and carve it out as a livery. And what that would have left us with a substantial oversupply of cabs, and the cab drivers would have been locked in with significant amounts of debt, and we would have had a real problem in our hands. So that plan is dead for a very good reason. I would point out, by the way, that the La Capra plan envisioned about 180 medallions being issued. At our meeting earlier this week, Mike said that no more than 120 are likely to be issued. That's a drop of a third in a 2-year period. If the La Capra plan was really a good plan 2 years ago, and now we should have a third less, that should tell you something about the dangers of locking ourselves into a medallion plan. You can add medallions if the market grows. You cannot take them away very easily at all.
Very good. Are there more questions from the floor? That being so, we're going to move to closing statements, and we begin with the opponents as proponents close last. And if you would, Mr. Sandman and Mr. Levitan. And you have 3 minutes.
Oh, you want us to?
Yes, please.
Start the code. Okay, all right. I beg your pardon, I thought the proponents would have that. All right, I'd like to come back to the basic point that I made in our opening statement. The Article 15 is not just intended to bring a halt to the plan to sell medallions. Article 15's proponents seek to open up the market to an unlimited number, whoever wants to bring a taxi cab out onto the streets of Brookline. And that carries with it a number of interesting problems. One, of course, is that we already have a large number of cabs on the street and no place to put them. Vehicles drive around or have to sit at a cab stand or occupy a parking meter, typically without paying the meter fee. If we have a large number of new entrants into the market, then we're going to have an ongoing, an additional problem. Secondly, Brookline isn't Manhattan, where taxis get most of their rides from people who hail them at the curb. 85% of the rides come through the taxi company's radio rooms. The average driver has 15 fares per shift, so he or she spends a lot of time waiting, driving around and hoping for a ride. More taxis will exacerbate our traffic and parking problems. It's very odd to hear Mr. Ellis talk about, or Chad talk about, a drop in the number of taxis, drop in the number of medallions initially, absolutely, but a drop in the number of taxis on a permanent basis on the one hand, and on the other hand say that they want to open up the market. Open up the market to whom? So opening up the market to anyone who can put a cab on the street will add more capacity. The income of full-time drivers will be hurt by part-timers who can cherry-pick the times they work and will close and will choose the busiest times, and the police already have a problem enforcing taxi regulations. This is what I say, that the core of the Article 15 is a belief in deregulation. And the proponents will tell you that, there'll be some disruption at the beginning, but it'll all settle down after a transition period. Yeah, in the long run, it might settle down, but in the long run, well, we're all dead. That won't do us any good now if a glut of cabs and a massive reshuffle of drivers and their incomes damages service and makes it even worse than it is today. Furthermore, Uber and its competitors have already opened up the market. Their rates aren't regulated, drivers aren't checked, and so forth. It works for a segment of the public, and that's fine. Brookline hasn't acted to limit Uber. To repeat what I said at the start, Article 15 is not about medallions. It's about ending regulations that limit the number of cabs and letting the free market take over. The free market's fine for restaurants and nail salons, but the history of the taxi industry suggests that it's not so good for taxi service or for taxi drivers.
There's 20 seconds left or so. Medallions have proven themselves to work in major cities around the country, and they've worked for the last 100 years, or almost 100 years. Uber has changed the system quite a bit. They've taken away some business from cabs, and they've made it difficult to find drivers. If you're smart, you won't put your daughter in an Uber cab. That's not a good thing. We heard from an advisory committee member whose 15-year-old daughter uses Uber on a regular basis. They don't regulate their drivers. It's not a smart thing to do.
Thank you.
I'm sorry, I'm being told to stop.
I wanted to make sure I was on solid ground. Mr. Harrison, Mr. Ellis, 3 minutes.
Yes, thank you. Basically, first, just briefly to respond to the notion that that anti-medallion people are Neanderthals, et cetera, believe in no regulation. Simply not true. I consider myself a proud progressive. I'm a board member of Brookline PACS. I'm a member of the Green Caucus of the town meeting, and I believe fully in the power of government to solve social problems and improve people's lives. The issue is, what is the appropriate use of government in a situation like this? And I propose that the appropriate use is what is called quality control of the taxi industry and not quantity control. When I say quality control, what I mean is the best way to upgrade taxis in Brookline is simply to issue very rigorous regulations of very high standards. Those standards should center on the vehicle itself, the safety, comfort, environmental features, et cetera, of the vehicle, on the driver, on the skills, the training, the moral fitness, et cetera, of the driver, including Corey checks, et cetera. And finally, on liability insurance, so that customers, if there is an accident, customers are well covered. These are issues of quality, not issues of quantity. Finally, I have a brief time left, and I want to talk about basically what we are really talking about here. This is the productive asset of the taxi industry is the vehicle itself. This is one vehicle called the Nissan NV200 taxi. It is New York City's taxi of tomorrow. The city of New York has chosen this when a vehicle goes off the road and is replaced. This is the vehicle that New York cab owners have to replace it with. I mentioned this. This is Nissan's version. Honda's got one. Toyota has got one. Dodge has one. Ford has one. The suggested retail price of this vehicle is $29,700, so about $30,000. Again, as I mentioned earlier, this is a vehicle of about the cost and quantity and features of a plumber, a landscaper, et cetera, et cetera. 1 minute, okay. Basically, and those people are not asking for medallions. A particular high cost in the taxi industry in particular, they have licenses. They do not have medallions.
Mr. Levitan, please.
And plumbers and landscapers do not.
Mr. Levitan, please.
Yeah. A particularly high cost, as it turns out, in the taxi industry is insurance, which could be as much as $20,000, but a taxi driver doesn't have to buy the plumber's tools of a plumber, let's say. So basically, there are also costs of maintenance, gas, dispatch, garage, et cetera, et cetera. It is reasonable to assume a startup cost of $40,000 to $50,000. That's startup, to buy your very first vehicle, to get a start. You may have to take a loan on part of that. You may not. And but small business owners all the time have to put in that kind of initial capital to get started in the business. And so none of those other people are asking for medallions. Again, the vehicle itself is the productive asset. That is the core. That's what we should be focusing on. There's no need to institute a medallion system so taxi people can buy the vehicle to make their livelihood. Thank you. I've run out of time.
And thank you all, gentlemen, very much. And I particularly want to thank the Brookline Interactive Group Studios for hosting us this evening, and our sponsors, the Brookline Neighborhood Alliance, Town Meeting Members Association, and the League of Women Voters of Brookline. Thank you all.